Tunatoka utumishi kutoka utumishi less than 24 ama 25. Those were not second years. Part of this proceeding Guru kasi gini teknologi coba sampai waktu kawan gini baru kan so that nothing is but you see final conclusion conviction I don't think it would be necessary.
Summarize the issues, resolve issues of the world.
Then tell us, you can't be a backlash. We're being told the street is 200 and odd pages. Ultimately, it is now less. The backlash will always come.
What is
yes, nothing. Even the Joe convicted and married. In fact, people ask what happened before her, and then there's some judgment, and she acquitted. But because of that, it's going to be a bit of a and our clients living in prison because the file is not there. That lady, she reads judgment from her head, then she goes to write. Okay, because that it must be recorded. Very sad. And you know that the fine now it's even worse that she's not in Kiambu anymore. Now imagine for us, it was happening when she was sleeping. Even before the liberty,
they have a matter that is coming now.
But the judge
That cannot. Yeah.
Is that appearing in the target number? It was Muranga. But she's also close to Nairobi and its environment. The farthest has been Naivasha. Mitigation of lakini kuna
onekana sasa ya we are going now having the NMRA part, and this is one folder for NMRA. Now when you go down, just go down. Now data management and workflow management, you see how we have structured this. Just go down.
Now, unaelewa
So you can see how they have been done.
aloketiwa wakati watu waliokapetiwa unaweza wajua
kuna watu
uko na interest yoyote kwa hizi
Which case?
Alafu sasa tumebaki na
the hostel guy.
Caspal, how are you? The numbers I don't see. Junior. The last interview people for that.
Hearing
Jangan saya pilih bisa kau dan kau sedang kau jual kau sana. Dia jangan saya. Jangan saya dijadikan ekonomi. Kira kalau kita mau kita hoki. Karena juga punya warna itu jangan it is not. Oh, itu kuat. Terus tadi dia nggak lebih karena itu yang besar lah. Itu beda lagi. Oke, sama itu lagi. Main buat pada hidup panggil kalau panggil. Ini aja kita jadi satu. Jadi itu lebih saya banyak hal kecil yang penting itu beda. Jadi jangan banyak bicara. Itu aja kita coba kembali ke segi besar. Teknik ini. Ini ada sedikit seperti banjir. Ini kecil. Itu masih sedikit di sini. Karena ini orang yang punya sekali. Saksi kita berdua kita pada ini OKBM menurutku dikasih. Orang dikit maki kopi yang di situ punya sampai situ. Asal nak peluang ini dojek lagi mas. Ah, ini kan oke sana ini ini. Kata mau. Yang tahu dari mana? Itu semua bisa ya. Ya, tahu dari ini. Kumpulnya dari mana? Kumpulnya dari mana? Kumpulnya dari mana? Kita ngomong ya. Ada orang ngomong yang orang itu kan duduk ada di sini. Punya itu. Kita tahu. Kalau gini pakai di kelas dari mana sih? Kalau aku mereka teknik dia, teknik mana? Correct. Orang of prevent is 15. 15 is
Kayak dia pasukan gitu. Kayak dia pasukan apa ya? Ini apa? Jalan terbang. Correct. Men kayak dia selalu decide. Jam cuma karena dia lain. Yes. Dongeng duka dongeng ini mangkaknya. Good. Pengamat kuah gitu kita.
nyaki job bawah.
Macam kayaknya bu. Yes, yes. Kita barang. Kalau dia jabuan, wajib buat, nolong wajib buat, wajib buat negara yang dicio. Nomor dicio.
Ini kan ada siasa lah. Ini kan siasa ucap.
Karena negara ini itu orang family berbeda.
Karena gue feel.
One way to bring a beach in a week. Menyiar. Oke sih orang
Oke ini kalau gini mati lori, gini masih serius.
Based on video drawing or Obiero captain, who attending court by an advocate of the rank of senior class. Kau sedikit kemana? Kau kerang. Jaga ya.
Puro lo dong siasa aja.
Kata kawan mana ya? You semua. Tiu. Dan ini isu sih. Dan aku sedih lah. His charm is also good. He's just a lucky man. Yeah. Correct. Dia yang baik like not just so he's always listen in system aja buat kalau punya kalau ini baras because of speaker buat berne domina social media ada kita kami his blog baru memang Oke, di blog kamu juga menggunakan kamera macam itu pak. So ini pak. Lo kita sendiri, di mau dia mak, oh siapa ya bro? Kamu apa nor? Kita jauh dia mak ngajar pada kamera. Ada campur ulu buat. Masa dua ke call buat, kita kurang profesional. Pada dua kenal. Buat.
Kulur di
Let me tell you, whatever we do in this house, kalau paman juga bedo mangnya, pesta mangnya bedo. Mangnya ngomong dia di luar.
Iya, udah.
Masanya pan korea mana project kemudian sekarang.
Ini feeling JC lo dua kepin lo.
Ini efek tadi, no kodo. Efek tadi, yes. No kodo kan. Kan from JC ni malah, produknya bedo ladangan.
Good morning, everyone. Or is it already afternoon? I want to start by apologizing for starting this session late, but much of the delay has been caused by some logistical challenges. which only emerged just around the time that we were supposed to have started. But we are here now. We can start the session. Today's session is meant to deliver judgment in criminal case number 46 of 2018. I can see Senior Counsel Mr. Kilukumi is here.
Yes, Your
So I invite you to address the court and introduce your colleagues for purposes of the record.
Yes.
For the quorum.
Your Ladyship, the appearance is as follows. Miss Timoi, Miss Kigira.
Miss Timoi.
Yes, Timoi. Miss Kigira and Miss Maina appear for the prosecution. They are all in brief for Miss Gishui. Counsel watching brief on behalf of the victim, we have Owor, Brenda Yambo.
Mr. Awor.
Yes.
Present, my lady.
Yes. Brenda Yambo, Letitia Mwavishi,
Mavisi.
Mwavisi,
Mwavisi.
yeah, and Victor Sirengo appear for the victim's family. My name is Kilukumi. I appear for the first accused, together with Mr. Sagana and Miss Mwanzia. Mr. Meso Oganda appears for the second accused.
Present, my lady.
And Mr. Oroga appears for the third accused.
Present, my lady.
Your Ladyship, we are ready to take the judgment.
Okay. Okay, this is the judgment. We will start with the information and background of this case. The three accused persons, that is Zakaria Okoth Obado, Michael Juma Oyamo, and Caspal Ojwang Obiero, hereinafter referred to as the first accused, the second accused, and the third accused respectively, are charged in 2 counts with the offense of murder, contrary to Section 203 as read with Section 204 of the Penal Code, Chapter 63 of the Laws of Kenya. The particulars in the first count being that between 3rd and 4th September 2018 at Owade area, Rachuonyo sub-county within Homabay County, the accused persons, jointly with others not before the court, murdered Sharon Berlin Otieno, hereinafter referred to as Sharon or the deceased. In the second count, it was alleged that between 3rd and 4th September at the same place, the accused persons, jointly with others not before the court, murdered baby Sharon. The court record shows that the accused persons took plea on 8th of October 2018 before Honorable Justice Jesse Lesit, now a judge of the Court of Appeal, and they denied charges in both counts. The case thereafter proceeded for full trial. It is important to note at the outset that the trial in this case has taken a long time to conclude due to several intervening factors. Those factors included the breakout of the COVID-19 pandemic and the resultant disruptions to court processes. The trial was also punctuated by several pre-trial issues and many interlocutory applications, starting with the applications relating to admission of the accused persons to board pending trial, and other applications which were handled by the second trial judge, Honorable Lady Justice Grace Genye Masharia, also a judge of the Court of Appeal currently, which were not concluded until the 27th of February 2020. There's a bit of interruptions from some quarter. I took over hearing of this case on the 5th of July 2021, and in the course of the trial, a significant amount of time was taken in the determination of interlocutory applications. It is noteworthy that in the course of the trial, I had and determined a record 16 interlocutory applications. Another reason which contributed to delay in the conclusion of this case was a transfer of the trial judge in September of 2022 after hearing a total of 25 witnesses. Hearing of the case thereafter stalled and resumed about a year later on the 17th of July 2023 after the Honorable Chief Justice directed that I should continue trying the case to its conclusion. The counsels in this case are as follows. I think it is important to mention the legal team that represented the parties during the trial. When the trial started, the lead prosecution counsel was Learned Counsel Ms. Catherine Mwaniki, assisted by Learned Counsel Ms. Gekoi Geshoe and Learned Counsel Ms. Betsy Gekonyo. But in the course of the trial, Ms. Gekoi Geshoe took over the role of lead prosecution counsel, assisted by Learned Counsel Ms. Betsy Gekonyo and at times Mr. Alan Mulama. On the defense side, the first accused was represented by Learned Counsel Mr. Kioko Kilukumi, Senior Counsel, assisted by Learned Counsel Mr. Rogers Sagana and Learned Counsel Ms. Mwanzia. The second accused was represented by Professor Tom Ojeda, Senior Counsel, assisted by Counsel Mr. Uganda Meso and Learned Counsel Ms. Catherine Msando. The third accused was represented by Learned Counsel Mr. Elisha Ogoya and Learned Counsel Mr. Jack Oronga. But in the course of the trial, Mr. Ogoya dropped from the case, leaving Mr. Oronga to continue representation of the third accused. Lastly, the victim's family was represented by Learned Counsel Mr. Daniel Joroge and Learned Counsel Mr. Hezekiel Awor. In support of his case, the prosecution called 42 witnesses and produced 81 exhibits. The prosecution case is that the first accused was at the material time the governor of Migori County, while the second accused was his personal assistant. The third accused was a clerical officer employed by the county government of Migori. The prosecution presented evidence that presented evidence that proved that the first accused was in an intimate sexual relationship with Sharon, who was then a second year student pursuing a diploma in medical health at Rogo University. Sharon's mother, Ms. Melida Auma Rangili, who testified as PW30, testified that in the year 2017, she was living together with Sharon and her 3 children in her home. In February or March of 2017, She recalled that Sharon was pregnant and she realized that Sharon was pregnant and seemed unhappy. Upon inquiry, Sharon confided in her that the first accused was responsible for her pregnancy and that he had become evasive as he was not picking her calls and had also withdrawn financial support. PW30 further recalled that between March and May of 2017, Sharon told her that she had met the first accused in Nairobi and he had told her that he was not ready for the pregnancy and she should terminate it. He gave her 30,000 to terminate the pregnancy and directed her to deal with the second accused for matters related to the pregnancy. Upon advice from PW30, that is her mother, Sharon decided to keep the pregnancy. According to the evidence of PW28, Mr. Lawrence Obonyo Owor, on 20th of July 2018, he was in one of the hotels in Homabay town when Sharon approached him seeking financial assistance. He promised to give her what he could on the following day. On the following day, they met in the same hotel, and as they were having tea, Sharon requested him to recommend a journalist who could assist by publishing her plight in the in the mainstream media to force the first accused to give her attention that she felt she deserved. On the 25th of July, PW28, that is Lawrence Owor, organized a meeting between Sharon and a journalist at Tourist Hotel in Homabay. The journalist testified as the journalist was PW9 and testified as a protected witness under the pseudonym of XYZ. According to PW9, Sharon narrated to him her personal details and confided that she was in an intimate relationship with the first accused who had abandoned her after impregnating her, and that at the time she was 7 months pregnant and as she was facing financial hardships, she wanted PW9's assistance by having her story published in the newspapers to force the first accused to reach out to her. PW9, that is SYZ, further recalled that he took photographs of the deceased and screenshots of WhatsApp communications between her and the first accused. Sharon also played 2 audio recordings of conversations between her and the first accused. And in the first recording, the first accused was pleading with Sharon to stop posting her images on social media, especially Facebook, particularly photos of hotels they had frequented, while in the second recording, he was beseeching her to procure an abortion, stating that time was actually running out. After a few days, PW9 communicated to the first accused through a mutual friend as he wanted to hear his side of the story before acceding to Sharon's request. When he reached out to the first accused through that mutual friend, the first accused called him, and in the course of their conversation, he invited him to visit his home at Rapoki together with PW28. They both accepted the first accused's invitation and went to his home the same evening. After sharing a meal, they had a meeting in which the issue of Sharon was discussed. And during that meeting, the first accused admitted knowledge of Sharon's pregnancy, but complained that her expectations of him, as narrated by PW9, were unrealistic, as she was demanding a good car, a house in Nairobi, and a good job. And in communicating these demands, PW9 indicated that he had Sharon's instructions to publish her illicit affair with the first accused in the media if her demands were not complied with. In response, the first accused requested PW28 to contain the situation by talking to Sharon and identifying her needs. He also advised that any future communication relating to Sharon's pregnancy should be channeled through the second accused, his personal assistant. According to PW9, at the end of the visit, as the first accused was bidding them goodbye, he instructed him not to tell anyone about Sharon's pregnancy. The second accused also called PW9 a few days later and notified him that Sharon's matter would be resolved amicably. About a week after the Rapogi meeting, PW28 met the first accused alone at Serena Hotel and later at Heron Hotel, also in Nairobi. PW28 in that meeting shared to the first accused information received from Sharon that Sharon required between 20 to 25 million to buy a house in Nairobi or Kisumu, a good vehicle, and money for her upkeep. The first accused made a counter proposal offering to buy her a plot at Homa Bay and constructing for her a 3-bedroomed house. PW28, that is Mula, was asked to share this counter proposal with Sharon and returned feedback to the first accused. And as instructed, PW28, Lawrence, discussed the matter with Sharon, who accepted the first accused's counter proposal. And when he communicated to the first accused Sharon's acceptance of her proposal, according to PW28, the first accused promised to avail the money needed for the purchase of the plot and the construction of the house by end of August 2018. On the 23rd of August 2018, PW1 recalled having received a call from Sharon informing him that the first accused, through the second accused, had requested to meet them in Nairobi urgently. PW9 then called the second accused for confirmation of that information, and the second accused confirmed that that was true, and added that the first accused would meet their transportation costs. And on the night of 23rd and 24th of August 2018, at around 3 a.m., PW9 received 22,000 through his M-Pesa from a lady identified as Veronica Wageshi. This was PW4. PW4 testified that she was on duty on 23rd of August 2018 as a receptionist at Sagret Hotel, Nairobi, when a man she was not able to identify requested her to send through her Safaricom line 22,210 to PW9's mobile number, allegedly because he did not have a Safaricom line. The second accused in his defense admitted having sent the above money to PW9 through PW4 to facilitate Sharon's and PW9's flight to Nairobi on the same day. There is evidence from PW5 and PW9 that Sharon and PW9 took an early morning flight from Kisumu to Nairobi on the 24th August 2018. On arrival, they met with the second accused at Capital Center, who later catered for their accommodation as he allegedly made efforts to schedule a meeting for them with the first accused. Unknown to Sharon and PW9, the second accused had also facilitated the travel of Lawrence Muller to Nairobi on the same day, ostensibly for the same purpose of having a meeting with the first accused. However, the promised meeting failed to take place, and disappointed the trial, that is PW9, Lawrence and Sharon, returned to Homa Bay in the evening of the following day. According to the evidence of PW9 and PW28, that is Stu Mura, between 27th and 29th of August, the second accused called them separately using an Airtel line number 0739473321, informing them that in future they should communicate with him using that line. He, however, gave them different reasons for that instruction. According to the evidence of PW9, the second accused claimed that he had lost his Safaricom line, and that is why he had asked them to communicate through the Airtel line. Well, according to Lawrence, he claimed that the second accused had claimed that his Safaricom line had been blocked by children and he had not had time to unblock it. Further, through the evidence of Noah Omondi Odoyo, who testified as PW26, an Airtel shop attendant in Migori, the prosecution alleged that the above Airtel line, that is the line that the second accused acquired and instructed PW9 and Muller to be using in any communication with him, that line had been registered using a national identity card, which was issued in the name of Vincent Abonyo. Vincent Abonyo, in his testimony, recalled that he had lost his identity card while at Kenya Commercial Bank in Migori, and that he had already obtained his replacement. He denied having registered the Airtel line used by the second accused to communicate to Sharon, PW9 and PW28. On the PW28 record that in late August 2018, the second accused called him using the Airtel line, and they subsequently had a meeting outside Tausi Hotel at Rodi, during which the second accused asked PW28 to keep off Sharon's affairs as he would henceforth deal with her issues. On being cross-examined by Mr. Award for the victim's family, Lawrence recalled having written a statement confirming that in that meeting, the second accused had asked him how they could get access to PW9's and Sharon's mobile phones since they contained evidence that could take the governor to the media. According to the evidence of XYZ, that is PW9, Sharon called him on the 3rd of September 2018 at about 5 p.m., informing him that the second accused had conveyed a request from the first accused that they should meet at Rodikopani in Homa Bay County. They acceded to second accused's request, and on arrival at Rodikopane, Sharon contacted the second accused, who redirected them to Rongo town. They proceeded to Rongo and went to Grasa Hotel, where they waited for the second accused. And when he eventually joined them in the hotel, the second accused informed them that the place was too open for him to communicate the message he had from the first accused. He requested that they should move to another venue. XYZ further testified that as they exited the hotel, they found a dark vehicle parked outside the hotel entrance, which the second accused allegedly asked them to board, claiming that it belonged to him. On boarding this vehicle, he noted that it already had two occupants, a driver and a person seated on the passenger seat. PW9 sat behind the driver. Sharon sat in the middle, while the second accused sat behind the front passenger seat. The vehicle then left the hotel, and as it was being driven towards Rongo town, and was driven towards Rongo town, but subsequently changed direction towards Homa Bay town. Along the way, near a petrol station, PW9 claims to have seen two people standing by the roadside. It was now evening around 7:30 p.m. He recalled that the second accused ordered the driver to slow down, and when he did, the second accused exited the vehicle. The two unknown men who were with them in the vehicle he had seen standing by the roadside entered the vehicle and sat at the rear seat, sandwiching Sharon and PW9. He was able to see the two men seated with them at the rear seat, but he was unable to see the driver and the man seated on the front passenger seat, who appeared to be receiving instructions from somewhere, as he was constantly on the phone. As the vehicle sped towards Homa Bay, one of the men ordered them to switch off their mobile phones and surrender them together with their other valuables, which they did. The same man, who he was not able to identify, asked him whether he had a tape recorder, and the other man started searching his pockets. The man seated next to Sharon, according to PW9, asked Sharon about her relationship with him and how she had met the governor, which Sharon explained. The man seated next to PW9 also asked him how he had met Sharon and why he was doing a story about the governor. And as Sharon got distressed and started crying, one of the men told her to stop crying as they were taking her to the governor. According to the evidence of PW9, as the conversation continued, and at this time the vehicle was still in motion, the man seated next to him became violent and started strangling him, asking him why he was following the story about the governor. This man then lowered his seat to an inclined position, and taking advantage of this development, PW1 wiggled his way from his grasp, opened the doorknob of this vehicle, and jumped out as the vehicle was still on transit. He fell on the tarmac and rolled off the road. And he also noted that the vehicle had stopped a distance away and two people started running towards him. He started running away from them in the direction of lights he saw from a distance, which led him to a home in which he took refuge. According to the prosecution case, this home belonged to Mr. Casera, who testified as PW27. In his evidence, he could not remember. Actually registered this line using an identity card issued in the name of Vincent on 3rd September 2018 at around 8 p.m. PW26 evidence was not shaken in cross-examination and went straight to hide under the bed in his bed. And I am convinced that he was surprised. His evidence represented the factual position regarding how the second accused acquired this man explained how he had been abducted, together the fact that with Sharon and how he had escaped. Drawing from the foregoing or drawing from that evidence, I am satisfied that the second accused, obviously referring to PW, fraudulently had acquired the Airtel line and for the sole objective of concealing his communication with the deceased, 27, PW9, then to PW28, police post, so that any such communication the matter would in future not be traced to him. PC Willie Okoti testified as PW number 6. His inconsistent explanations recalled having noted to PW9 and PW28 regarding the reason he had procured the line demonstrates lack of truthfulness. He also noted and undermines the credibility of his testimony. He was trembling when making his report. More importantly, he then booked the fact that the line was fraudulently also disseminated it just days before Sharon's murder, coupled with the second accused's insistence that the line be used as the exclusive channel of communication between Sharon, PW9 and PW28, who accompanied by other police officers. The only two people who had become Sharon's close associates, PW11, leads me to an irresistible inference that They went to
this
Kadal
line
police post,
was acquired
picked PW9
as part
escorted him
of
to
acts
Kedube
of
police
preparation
to Kedube
for
sub-county
commission
hospital for
of the
treatment.
offence.
At the hospital, he was treated by
Regarding the
clinical
events of
officer,
that September
Mr. Haran Diero
2018,
Kajwang,
which
who testified
needless
as
to state
PW10.
is the
In his
date
evidence,
that Sharon was
the clinical
abducted
officer recalled
and
having noted
subsequently killed.
fresh injuries on PW1.
The prosecution led evidence seeking to prove that there was a preparatory meeting held at the third accused's wife's home, that is Olivia's home,
were soft tissue injuries
in the
since
morning.
there were no fractures.
PW38 testified that he found
on a notebook
the third accused
on the
seated
basis of
outside
which
the
he
home
later
with an
filled
apparent
a
meeting
form, which he
with
produced
one dicky.
in evidence as exhibit number
With one dicky.
16.
Olivia and Elvis were inside the house.
In the course of his long and
PW38
detailed
had gone to the house to pick a
and
copy of the
detailed
subject
testimony,
vehicle's
which the
logbook
court recorded
to
for
facilitate
several days.
its valuation.
PW9
In his
identified
evidence
the
under cross-examination,
vehicle in which
PW38
he was allegedly
clarified
abducted
that he had confused the time that he had gone to the home.
It was motor vehicle
that
registration
it
number
must have been
KCL
after 12 or 3 p.m.
a Toyota Fielder grey
since he
car,
went to the home.
which according
after
to
talking
records
to Olivia.
maintained at the National Transport
The second and third accused
Authority, NTSA,
denied having
was
attended
owned
any
by
such meeting,
Miss Olivia
claiming that they
Olo,
did not leave their places of work on
who
that
was the
day.
third accused.
Under cross-examination, however, the third
The
accused
vehicle was
recalled
being
that in
operated
his statement
as
to the
a
police,
taxi,
he had
and
actually
his
admitted
driver was
that he was
a
at
Mr.
Olivia's
Jackson
home
Otieno Gome,
on that day
who
around midday.
testified as PW38.
Although the second
According
accused
to
claimed that on that day he was busy in his
Mr.
office
Gombe,
preparing for an official
on
trip
the
to
3rd of
Rwanda on the
September
following day,
2018,
the email correspondence from the
he
travel
received
agent,
instructions
which he produced as Defense
from
Exhibit 4,
Olivia, who was the owner of
indicated
this
that
vehicle,
as late as
who instructed him to
12:59
take
p.m.
the vehicle for valuation
His
at Invesco
ticket
Insurance in Megori.
to Rwanda
Migori, sorry.
had not been confirmed, as it was still on the waiting
PW38
list.
recalled that accused number
Elvis,
3
who testified as defense witness
directed
4,
him to the insurance
also denied
company
having been
offices
present
to get
at Olivia's home
the
at the
valuers'
time alleged.
telephone number. And after getting in touch with the valuer,
I must state
he
in,
proceeded
that in
to
my
Olivia's house
assessment,
to get a copy of the
I found
vehicle's
Elvis, or
On
Elvis
arrival,
struck me as an untruthful witness,
in Olivia's
considering
home.
that
He claims to have found
claimed
the second, the third, and another person
in his
identified
evidence
as DK,
that he did not know
treated
Sharon
together outside the house.
or her relationship with the first accused, despite the fact that
he also
there
recalled
was
that
evidence which he
as
admitted
he was living,
that he had been one of the first accused's bodyguards and had worked in that
this
capacity
Olivia allegedly warned him not to tell anyone
for
about what he had witnessed or what he had seen in that
for 10 years.
In addition, PW38 testified that after
in the circumstances,
testified that
he
later
claimed
the
that
same day,
he was
between
not aware
4 and
of
5 p.m.
that relationship
a police
was
officer
implausible
known as Elvis,
and can only mean
who also testified in
that
support
he cannot
of the second
be taken to have been a
person's
credible
case.
witness. I therefore
who was also
do not give any weight
one of the bodyguards attached
to his
the
claim,
first accused,
to his evidence.
called PW38.
Continuing with the evidence adduced relating
And
to the events of that
instructed
September
him
2018, the
the
prosecution
second accused
also
at
tendered evidence through the evidence
At
of
around 6 p.m.
PW9 and PW13, not 13,
and that the
PW38,
second accused would
to
then
prove that
direct him
the second accused,
where to
the
go.
second accused convened a meeting
He claims
with Sharon
he claimed that
and
he knew
PW9
Elvis
at
as
Grasha
used to see
Hotel
him with the first
in the
and third
evening.
accused.
This meeting,
And he sometimes
as noted
gave him
earlier, was
such as picking up customers and
acknowledged by the second accused in his evidence,
to third accused or his
and he
wife.
admitted having met Sharon and
PW38
PW9 in
recalled
that hotel
he complied with those
to
instructions
deliver a message from the
proceeded
first
to Oriri,
accused,
where he found the second accused in the company of two unknown men. The three of them boarded the vehicle and he drove them to Gracia Hotel, following instructions from the second accused.
There is also evidence
On arrival at the hotel,
which was
the second accused,
which was also admitted by the second accused that
was the only person who
he left this hotel together
went
with Sharon
to
and
the hotel, for the other two men
and PW9
were left standing behind the vehicle.
And
after about 10
although
to
there
20
was
minutes,
conflicting evidence between the
second
evidence
accused
given by
emerged from
PW9
the
and
hotel,
PW38
accompanied by a lady
regarding the manner in which
and another person.
the manner
Or
in
another
which
man.
that the manner in which these two witnesses,
According to
this, Sharon and
his further
PW9,
evidence,
together with the second accused, left the hotel.
all the unidentified
There is
men
evidence
who had
that
been in the company of the second accused
PW9
boarded
and
the
Sharon
vehicle.
boarded
But
the
second
vehicle that
accused
was being
did
driven
not.
by PW38.
One of these men instructed him to drive to a nearby petrol
Whereas
station
there is,
and
according
park
to
by the
PW9,
roadside, which he did.
the second accused also boarded the same
Shortly
vehicle.
thereafter, the second accused joined them.
There is
appearing to have
evidence
crossed
that
over
this
on
is the
foot
vehicle
from
in
Russia
which the
Hotel.
second accused, no, Sharon and
And after the
PW9
second accused
were allegedly were
engaged in a
kidnapped,
discussion,
and
the
the vehicle that
with the unidentified men,
and it is this vehicle that transported
these men
the late
boarded
Sharon
the
to the
vehicle.
scene in which
one
she
on
was
each side
subsequently
of the
killed.
Two of them sat on each side of the rear of the
I
rear
have
seat of
noted the
vehicle.
discrepancy between PW9's and PW38's evidence
Meaning that
regarding
Sharon
whether or not the second
and,
accused boarded the subject motor vehicle.
PW9
In my mind,
between these
while
two,
the accounts
where
of
the other
PW9
man
and PW38
sat at
differ
the
on the precise
the
sequence
front passenger seat.
of how they left the scene. They converge on
According
the
to
critical point
PW38, Mr.
that
Bombe,
on the 3rd of September 2018, the second accused
when
was
driving towards
with the
Kisumu,
deceased
was
PW9 at Gracia
by one
Hotel
of these
in the
unidentified
company
men.
of unidentified men, and the final point of separation was either
and
at the hotel gate or
about
the
their
roadside
relationship
near
with
the
the-
petrol
with the
station.
governor.
Whether the second accused boarded the vehicle at the hotel or
He
joined
decided
them
not
later
to
is immaterial.
follow up with the conversation.
Both witnesses
This did not
confirmed
concern him.
that he was present
And he increased the volume of music in the vehicle.
and was involved
After
at the
driving
precise
for
moment.
some time,
And although
he
the second
sensed a
accused
gush
in his
of-
defense
he
denied
claims to have
knowledge
sensed a gush of wind blow
of
into the
or
vehicle.
any
As if
association
the
with
rear
the
door
unidentified
or window
men,
had been
he
opened.
did not challenge the evidence of PW9 and
He recalled
PW38
that he was at the time
about
driving
the
at a
presence
speed of about
of these
60 kilometers
unidentified
per hour.
men or his
slowed
association
down.
with them.
And on asking what was happening, one of the
It is
men
important to mention
seated
that in
behind
their
him,
written submissions, learned counsel
dismissed
for each
him
of the
saying,
accused
"Wachana na hii
persons
fala,"
submitted at
and he
length on
proceeded with his journey.
their foregoing contradictions and strongly
As
attacked
he
the credibility of
continued
PW9 and
driving, he was being
PW38,
by one of the
asserting that the
unidentified men
evidence
on the
was
roads to
planted and
And eventually
was
he was
fabricated.
led to Arab
The attack on PW9's credibility was mainly
no
two
homes
pronged. First, it was admitted that he was not a
At
truthful
some
witness,
point,
because he had earlier described the motor vehicle used in his and Sharon's abduction as black.
Vehicle's engine as well as its
But
lights.
when the vehicle was produced in court for identification, it turned out that it was grey in color. Secondly, it was admitted that it was not because it was not possible for him
one man
to have
who was previously in the vehicle
jumped
was no longer
out
there.
of
As when
moving
the occupants of his vehicle alighted, he noted that
allegedly traveling at a speed of 80 kilometers per hour and survived
of
with
them
only minor injuries without serious fractures.
as only
The challenge
and
on
women alighted.
PW 38
He complied with instructions to it.
Was to the effect that he was a planted witness,
And after about
because
10 to 20
his
minutes,
evidence was full of
the three men
falsehoods,
returned, but without
and it
the
was, and the court was urged
upon
to
inquiry,
find that his
was informed that the
evidence
lady had
ought
been
not to be believed
at their home.
because he gave different statements to the
He
police
was then directed to drive to
during
Obado,
investigations,
where the unknown men alighted.
some of
between
which
9 and
differed
10 p.m.
with the evidence that he gave to the
He
court.
thereafter drove to his home in Migori.
The test used by courts to determine the,
The
impact
prosecution
of
also
contradictions
tendered
or
evidence
inconsistencies
that in the morning
on
of
the
4th
prosecution's
September
case is a
2018,
substantive one. It requires the court to inquire whether the contradictions or consistencies were so material
Mr. Justice
to the issues in question that they would deal a fatal blow
from a man
to the
who
prosecution
identified
case.
himself as Caspal Obiero.
In the case of Eric Onyango Odeng versus Republic, the Court of Appeal held that minor discrepancies and inconsistencies in the evidence of prosecution witnesses were natural and inevitable, where different witnesses recounted the same events from different perspectives.
He recalled that after
Such
receiving
inconsistencies
from the third accused,
would not render the prosecution's case unreliable
in the hospital,
unless they were
accompanied
material
by the second
and go to
accused.
the root of the charge, or that they
The
created
third
reasonable
accused
doubt as to the guilt of the accused,
Then
or
informed
demonstrated
him
deliberate
that
falsehood.
they required his assistance in an issue
The
related
Court of
to
Appeal
treatment.
guided that only grave and unexplained
The second
contradictions
accused
that affect the substance of the
took over the
prosecution's
conversation
case
and explained
may
that
justify
he had been
rejecting
attacked
the evidence.
by unknown people the previous night at PC, and he had been robbed.
I have
of
keenly
money belonging
considered the contradictions
to the
which
first
the
accused.
defense has made very heavy weather. Has made very
That
heavy
he
weather
therefore
of during
needed
cross
a medical
examination
request form
and in their
issued
submissions.
by a hospital
I
in
find that the
PC,
contradictions in the evidence of
confirming
PW9
that he
and
had sustained
PW38
injuries on the previous
related
night,
to whether the second accused
as he
related
needed
to
to
whether the
protect
second
his job.
accused boarded the vehicle at the hotel, whether the vehicle had
PW22
music,
recalled that
and whether the late Sharon expressed
upon
distress
receiving this
when the
request,
vehicle was on transit.
he contacted his colleague at Kisii Teaching and Referral
In my
Hospital.
opinion,
His
these
friend was
contradictions
Mr. Cliff
related
Omani,
to
who
peripheral
testified as
matters
PW20.
that did not go to the root
PW20
of the
recalled
prosecution
that
case.
on this date, that
With
is
respect to the
4th of
contradictions in
September
PW9's
2018,
evidence,
at around 10:30 a.m.,
PW9
he was at his place
explained
of work
that he
when
had
he received
described the subject vehicle as dark or black, dark stroke black,
He was at his place
because
of
he had
work
seen it
when
at
he
night in
received a
circumstances
call
that did
from
not allow
his friend
to see
Mr. Mundi,
to see its color properly.
requested him
This
to
explanation
assist his friend, who he identified as Mr. Michael Oyamo, by issuing him with a medical
this explanation in my view
prescribing
is reasonable
multiple
and
medical investigations,
does not
including chest X-rays, MRI.
This explanation is, in my view, reasonable and does not indicate,
and although he did not know
or is not evidence of any dishonesty or
he fabricated treatment notes and a computer-generated
in the evidence of PW9,
purportedly
because even considering ordinary circumstances, Kalagre fits the description of Dark
as a favor to his friend, Mr. Justice.
Considering that even in ordinary circumstances, Kalagre fits the description
A and B
of a dark as opposed to a bright color like white, cream,
he recalled that
yellow, orange, or whatever other bright color you can think about, and may look like black whenever viewed in the darkness. In any event,
PW22.
It is common knowledge that a vehicle is identified through its registration number
on the instructions
and not through its color.
On the same day,
in my considered view, the contradictions in PW9 and PW38 evidence were not fundamental to the key issues in question in this case, and were thus not fatal to the prosecution
that
case.
is Philomene Fidel.
Regarding the challenge on PW9's and PW38's
at the police
credibility,
station on duty,
contrary to the defense's submissions,
the second accused
I find nothing on record that would cast
went to
aspersions
the police station
on the credibility
and
of these
reported a case
witnesses.
of abduction.
I watched the witnesses as they testified,
According to
and
PW23,
in my view, they gave
the
clear,
second accused alleged
detailed,
that,
and
on the evening of 3rd
consistent
September,
eyewitness accounts of the events that
he
took
was
place
at
on that
Grasha
September
Hotel with a
2018.
lady by the name of Sharon and another man, and that on leaving the hotel,
PW38 explained
they were
that the
abducted
few
in an
contradictions
undisclosed vehicle.
in the various statements he recorded
That
with
he
the
found
police
himself
were as a result
in PC the
of the
following
structured
morning,
approach
having
used
lost
by the investigating officers, which
270,000
restricted him to answering
the first
only
accused.
questions put to him. And
Upon receiving
these
this report,
contradictions in that context cannot be
PW3
viewed as
instructed
indicative of
the police officer then
untruthfulness
manning the report
on the
office,
part of
who testified as
PW38.
PW24,
With
to
respect
record the
to
report
PW9's
in the
evidence,
station's occurrence book,
his claim
which was done.
that he escaped from the subject
The
vehicle
extract of that
when it was in motion
report
was materially
was produced
corroborated by
in
PW27,
evidence as prosecution
in whose
expert
home
testified.
he sought refuge. PW6, who recorded his abduction report at Cadell
After
Police
this
Post,
report was recorded,
and PW9, who treated him for his injuries.
PW23 was made aware
PW27's
of
evidence
the abduction
regarding how
report that had been made by PW9
stormed into
the
his
previous
house
evening
out of
at
breath,
Cadell Police Post.
visibly shaken and in a panic.
And he formed the opinion that
And the
report
fact that
made by
the first
second
instinct
accused was suspicious.
of PW9
And
was to hide
the
at
second
the
accused
bed
was
is quite telling.
therefore arrested for further investigations.
In addition, the description by PW6 and PW10
On the same day,
PW6 was the police officer who
around
recorded
3 p.m., this
his
is now
PW9's
the 4th
report
of
at Cadell Police Post.
2018.
PW10 was the clinical officer who treated him.
Sharon's lifeless
And
body
the fact that
was discovered in a bush
these two
near
witnesses
Owade River
confirmed in their evidence
by
that
Moses,
when
by
they
Mr.
saw
Moses
PW9,
Oguta,
he was visibly shaking
a resident
to an extent that he was trembling
a resident of
when he was
Owade village.
recording his statement or when he was being treated. These
Moses-
accounts by these two
Moses
witnesses reinforced
who testified as
PW9's claim that he had
was
just escaped
shepherding
from a
his cattle
life-threatening
towards his
situation.
home when he stumbled
Additionally,
upon
in the course of
Sharon's
the
body.
trial, PW9,
He reported
demonstrated
the
to the
matter
court
or this discovery
how
at
he had
Oyugi's police
managed to
station.
jump out from the moving
He was
vehicle,
escorted
which
by police
according
officers,
to
namely Inspector Mary
PW38 had been moving at a speed of 60 kilometers per hour approximately,
PW19,
and not
to the
80
scene
kilometers per hour
where
as alleged by
he
the
had-
defense.
where he had left this body.
Further,
And they found
PW4's
members of the
attempt
public
to
already
discredit PW9's
PW18 and
evidence
PW19
on
recalled
this point
having noted
failed,
that the body was lying
dismally failed, because
the body was naked,
since he admitted
lying
that
face
his
down in a
expertise
pool
was
of blood.
only limited to motor vehicle
As part
assessments.
of her preliminary
He
investigations,
was not an expert on the law of motion
PW18,
in his own admission,
this is a Mary
and
Mugire,
that he was not in his admission.
recovered
He was only his only
recovered
expertise related to motor vehicle assessments,
the items,
and he was not therefore an
he found-
expert
she
on
found
the law
at
of
the scene
motion
and
and
prepared
assessment
an inventory
of impact
of the same.
that would be expected
The
of a
items
person
included
or an
items
object
of
falling or
and open shoes belonging to
or
Sharon,
falling from a moving
2
motor
used
vehicle.
condoms, 3 sachets of trust condoms, 2 cover
Having
packets
satisfied
of
myself
trust
that
condoms,
PW9 and
a sachet
PW9 and
some
PW38 were in fact credible witnesses, I find that the prosecution has proved
PW18 Mary
beyond
Inspector Mary
any
Mugire
doubt
and PC
that the
Sally
second
Mutiki,
accused was present at
after
Grasha Hotel
those preliminary
and at the
investigations, collected the
nearby
body
Olivia
and took it to
petrol
Rajonyo
station
District Hospital
in the
for
company
treatment.
of unidentified
preservation.
men who boarded motor vehicle registration number KCL
On the 8th of
481K,
September 2018,
who joined PW9 in Sharon. There is uncontested evidence that the unidentified men were the culprits who abducted,
according
sexually
to the evidence
assaulted,
of PW29,
and eventually killed the late Sharon.
he identified the late Sharon's body
Given the
to
above evidence,
the government
I
pathologist,
I strongly take the view that the
PW1,
meeting at Grasha
who
Hotel
conducted an autopsy
was not genuinely
on the body.
intended to convey
In
the
his
first
testimony,
accused message to the deceased and
PW1 recalled
PW9,
that on examining
but
the
was
body,
in reality
he noted multiple
deliberate
external
entrapment
injuries consisting of
to
2
hand over
slash
the
wounds
deceased to her killers or
under
to
the
her
right
assailants.
and left ear,
Additionally,
and a total of
the
7
above
deep
evidence
stab
also
wounds.
demonstrated
One at
that the first
one at
accused,
Sharon's abdominal
although
area,
physically absent,
and the others at several areas.
must have been aware
of her
at the
back.
meeting at Grasha Hotel.
He, after his
Since
examination, he
in
opened
the second
opened
accused's
that
admission,
the deceased cause of death was
he's the one who had sent
hemorrhage
him
due to
to deliver
penetrating force
money
trauma
to Sharon in that
with
hotel.
features of manual
It is
strangulation.
also apparent
He
that
documented his findings
according
in a postmortem
to
report, which he produced
PW
as Exhibit 1.
according to PW9 and PW38,
In the course of his
the
examination,
conversations
he also
that
noted
these unidentified men
that
had
the deceased
with the late
uterus
Sharon
had a dead
and
fetus,
PW9
which was 28 weeks old. The stab wound to Sharon's abdomen
led-
had penetrated to the uterus, gone through the fetus's
the conversations
abdomen,
that these
and came out
unidentified
through the
men had
mucus.
with the late Sharon and PW9, according to
He
PW9
prepared-
and
he also prepared
PW38, who I have
and
already
signed a postmortem
found
form
were credible witnesses,
in respect of the
demonst-
fetus,
give
which he
an
produced
inference
as Exhibit 1.
that these unidentified men had
Upon cross-examination
some
by
linkage
Mr.
to the
Kilukumi,
first
senior
accused
counsel for the first accused,
and appeared
PW1 confirmed
intent
that with
on
that
protecting
kind of
him,
injury,
considering
the
that
fetus did not have
they
any
questioned
chance of being born.
Sharon and PW9 regarding
As reports in
their
both the
relationship with
mainstream
the first
and
accused,
social media platforms
and why
started
PW9
circulating
was following a story
regarding the circumstances
about
in
the
which
first
Sharon
accused.
and her unborn baby were found dead. And given the public
turning now to the alleged involvement of PW9 in a team of officers from the Directorate of Criminal
turning now
to the evidence adduced by the prosecution,
that is DCI headquarters,
seeking to prove or seeking to establish
to take over investigations into the matter. This team of officers included Chief Inspector Nicholas Konara Olesen,
the third accused. Turning now to the evidence adduced by the prosecution, seeking to establish the third accused's alleged involvement,
and he narrated to the court how investigations
in having a scheme to unlawfully kill Sharon.
In this case were
I find that in his defense,
the
third accused denied having played any role in Sharon's death.
According to his evidence,
and as
together with his co-investigators,
noted earlier, they emphasized that he did not have any reason
and commenced
to be involved in her death because
they found
he even bearing
already under arrest.
But he admitted
in the course
having
of
accompanied the second accused to meetings in which
recorded and
the late Sharon was involved twice. The first meeting was in a hotel at Homabay,
as prosecution
when the second accused was delivering money to Sharon on behalf of the first accused.
And this included,
and the second one was at Capital Center during the Nairobi visit.
The health records and information officer at
the prosecution also
at Kisii Teaching and Referral Hospital. This
linked the third accused to the commission of this offense, because by the fact that the vehicle used in
medical records
in the abduction
allegedly obtained
and
by the
eventual
from PW
transportation of Sharon to the place in which she met her death
did not emanate
was
from
owned
the hospital
by Olivia,
and they were
who was his second wife.
He also recorded that he had obtained
PW 39 confirmed in her evidence that the third accused wife had been given access to the tracking device in the subject motor vehicle through a letter she produced in evidence
after the
as prosecution exhibit 53C, and that between 3rd September 2018 and the morning of the 4th September, the tracking device
of that September
was not working, and indicated that it was either tampered with or disabled
in the course of
by failing to load its SIM card
in a bid to obtain.
It must be remembered
footage
that the 3rd September
about the happenings
is the day that the late Sharon was killed.
But he was unable
the
to
fact that the tracking device failed
as the device
at
for
the very time
of
that
CCTV images,
the vehicle
that is the
in which Sharon was abducted was being used for the commission
his
of an
investigations
offense.
Also
for the commission of the offense
of motor vehicle
cannot be a case of mere coincidence.
41K.
The two explanations given by PW1
had been
PW9 regarding why the tracking device which is functioning
and PW9
involved
after this vehicle
deliberate human intervention
by PW9. He produced it,
which means
in evidence
that
in support of the prosecution case as
the disablement of this tracking device was not a matter of a technological failure or something to that effect.
Further investigations led to
interference with the
DNA,
with this device
profiles
on the day that Sharon was abducted
and
later killed,
which according to the government analyst Mr. John Kimani Mugai,
a strong basis upon which a strong inference
confirmed or
can be made that regard to the preparation and concealment of
he produced
of the purpose for which
a report
this
documenting his findings dated
this device
March 2020
was made unfunctionable.
In the course of
It demonstrated
his
planning
together with his team,
and intention to avoid detection.
PW 42
The prosecution also adduced evidence to prove that on the 4th September 2018, a day after the offence was committed, the third accused introduced the second accused to PW22, requesting him to procure fake medical records
and Huawei tablet belonging
which
to the
were
deceased.
generated by
The phones were
PW20
as exhibits
on the request by
in this
PW22.
and a cybercrime and the cybercrime
It is apparent from the above fabricated
showing
medical
text
reports
messages and images contained in their
that
first
they were
forms
meant to support
was
a
also
report
produced
made at Oriri
as
Police
a
Station
51
to PW3
notably
on the same day by the second accused,
this forensic
claiming that he had been abducted
report
by unknown people on the previous
showed
evening,
that
in the course of which he had been
the
beaten
iPhone marked
and robbed.
the iPhone belonging to the first accused.
Investigations
Text
revealed
messages
that
only to
this report
that
by
is,
the second
on the 12th
accused
and 13th of September 2018
was a false report.
PW42 also recalled having obtained call data records from two service providers, namely Airtel and Safaricom Limited.
And this
In
is what
respect of
meant
mobile-
to his arrest at
in
Oriri Police Station.
respect of mobile lines used
And
by
though PW
the late Sharon, PW28
Though there's-
accused one,
Though both the second and third
accused
accused
three,
persons denied having ever requested
and
PW22 for procurement of these false
together with
medical
their M-Pesa
reports,
records.
they failed to explain how the said
reports
documents,
containing
both the second
above
accused
details
name
were
and
also
personal
produced
details.
in evidence.
Importantly, the second
by
accused did not
PW22
disown those
effectively.
details.
Another
two
witness,
accused-
that
the
is
submissions made
PW41,
on behalf of the two accused persons, impugning PW22's evidence on grounds that he had handed over the documents to the second accused at around midday, when the second accused was already at Oriri Police Station, are, in my view, with a lot of respect, misplaced. They appear to be
was
based on a
acquired by the
misapprehension
second accused
of
on the
PW22's evidence.
27th of August.
PW22 clearly stated
The
in his
subscriber
evidence
details showed
that he
that the
handed
line was
over the
registered
fake medical records to the third
under
accused
the name of
on
Vincent
instructions by
Abonyi.
the second accused. He did not say
That
in
who
his
was a
evidence
PW8.
that he had handed over the documents to the second accused.
In the course of his investigations,
In my view,
recorded-
the denial by the second and third accused that the denial by the second and third accused of involvement in the procurement of the forged medical records amounted to mere denials or afterthoughts, which did not affect the veracity of the two prosecution witnesses. These witnesses were independent witnesses in this case, and no reason was given by either the first or second accused that they had any reason to fabricate or give false evidence against them, against the two accused
reactivated
persons.
on the following day.
That said, I agree with the second accused that PW42's claim, that is the investigating
Of the
officer's
fact
claim,
that the
he
the tracking device
that the
had
second
either been
accused
tampered
is the
with
person who
or
presented
was
the false
disabled
medical report or the false medical records to Oriri police station when making his abduction report, and that the investigating officer collected the medical reports from Oriri police station in the course of his investigations cannot be true. This claim by PW 42
his investigations
was not supported by the rest of the evidence on record.
The prosecution of the
there is evidence from the arresting officers at Oriri police station that at the time the accused was arrested, he was searched, and nothing in the nature of documents were found in his possession. The other reason that I have made a finding that PW42's evidence on that aspect was untrue is because that claim that he had collected these false medical reports at Oriri police station where they had been taken to the accused person flies in the face of the letter dated 13th June 2022 produced by the second accused as defense exhibit 4, in which the investigating team was giving the second accused a notice through his advocates to produce original copies of the same documents.
In the result, this court found that the accused persons did not have a case to answer in count 2, and each of them was accordingly acquitted.
And thoroughly evaluated the evidence presented by the prosecution
when the accused persons
in support of his claim that the third accused,
each of them elected
jointly
a sworn statement
with the other accused persons,
and the third accused persons did not call
or
additional
other
witnesses,
persons not before
but the second
court.
accused called 2 witnesses.
Execute in
common
his
evidence. The first
having
accused
thoroughly examined
denied
the
having
prosecution's
committed the
case,
offences alleged,
seeking
or having
to prove
conspired with
that
the second and third accused persons,
that the third
or
accused
any other person to murder the deceased.
Planned.
He admitted having
the
had an intimate sexual relationship
in conjunction
with
the accused person
from November 2017
execution
that
of their common intention
in February or March
to cause the death of the second of the
he decided
to cause the
terminate
death
the
of
relationship,
Sharon,
allegedly because he discovered that Sharon had lied to him about having
and
a stationary
and having
business,
juxtaposed that evidence or
and
compared
that she had
that
also lied
evidence
about the
with
number
the
of her
evidence
children
adduced
and
by
the men
the
in her
third
life.
accused.
He also testified
I have come to the
that
conclusion
when Sharon
that the
informed
third
him
accused was not a
about her
passive
pregnancy in
bystander,
March 2018,
but was an active participant
although he had
in the
decided
events
to
that
terminate
resulted in
their
Sharon's death.
relationship,
His conduct
he was
was assisting
comfortable
the
with the
second
pregnancy,
accused to
and he
invent a
continued
false
giving her
alibi to cover
financial
his
support
tracks
for
on the
her
night
upkeep
Sharon was unlawfully
antenatal
killed
clinics,
is
either
incompatible
directly
with his
or through the
innocence.
second accused or through Lawrence Mueller. That is
It is
PW
also
28.
noteworthy
He, however,
that although the
admitted
third
that he had grown
accused
distant
testified
and that the level
that
of
he
his
did not report
financial
directly
support
to the first accused
dwindling.
in the course of his duties.
The first
The
accused
data records produced by
also
PW40
supported
in
PW1's
respect of the first
PW9's
accused
testimony
mobile
that sometimes in August
mobile number
2018
that is
he communicated
0722
with
469
PW9
587
and gave him an
shows that
appointment to
in
visit him
the
at
2
his
days
home in
between
Nakuru.
2nd and 3rd September
That
2018,
PW9 honored the appointment
the first accused
and went to
made
his
a
home
total
accompanied by
of 5 calls
PW8.
to the third accused.
The three of them had a meeting which was also attended by his
The call data
spouse.
records produced as XB64
He further recalled that in
show
that
that The first accused
PW
made the
Line
first two calls
threatened to publish his
on 2nd
relationship
September
with Sharon in the
2018.
media.
And the
that
other
in
3
his
calls were
response,
made on that September 2018. The third accused
told him to
call to the first
go
accused
ahead
was
with
made
his
on the
plans,
following day. That
his
is on
family
4th
and
September
his communication team
at 7:31
already knew about
PM.
it, and the information was in any event in the public domain through social media.
The number of these calls
Regarding
per
his
day
interactions with PW28,
on days
he admitted having had meetings
on days that
with
were
PW28 in Nairobi
either
and
just
having
before
used him as an
or on the
intermediary
day
to channel funds
that
to Sharon, in addition to
the offense was
second
committed.
accused.
And on the day subsequent to commission of the offense,
He also
give a reasonable
stated
inference
that
that
through
these calls
PW28,
were made
he managed to have the deceased
for purposes that were
abandon her
connected
earlier demands
to the offense that was committed
and
on the 3rd of
accepted
September
to have him
2018.
buy her a plot in rural Homa Bay, in which he would construct and furnish for her
Or for purposes
a 3-bedroom
that
house.
were in furtherance of ensuring that there was planning and coordination of the events that led to the commission of the offense on that date. I make that finding based on the timing and the frequency of those calls, and also because the content of those calls were matters that were within the special knowledge of both the first and the third accused persons. And under section 111 subsection 1 of the Evidence Act, the burden of proof shifted to the accused persons to explain the reasons that these calls were made in the manner in which they were made, and in order to rebut the presumption that the calls had been made for an illegal purpose. The first and the third accused failed to discharge that burden. Having carefully appraised the evidence on record in its entirety, it is clear to me that the evidence demonstrated it is clear that the evidence adduced by the prosecution in this case demonstrated and left no doubt that the accused persons acted in concert, jointly with others not before the court, pursuant to a common design, each performing a distinct role in furtherance of a criminal enterprise that resulted in the death of the late Sharon. To summarize, the first accused supplied motive, instigation, and funds to finance the criminal enterprise. The second accused facilitated execution, while the third accused ensured logistical support and concealment to avoid detection of the offense. Inherent in these roles were acts of preparation and concealment, denoting knowledge, participation, premeditation, and intention to execute their common intention aimed at executing their common intention that ultimately led to the death of Sharon. These acts constituted malice aforethought as defined in section 206 of the Penal Code. The fact that the first accused alibi that he was not in Migori County at the time the offense was committed, and the same was vindicated by the evidence that was produced in this case, and that he was in Nairobi from the 2nd of September all through, even from who was in Nairobi from the 2nd of September. It was not therefore physically in Migori when the offense was committed. That's not meaning that he was not physically present in the place where this offense was committed. Does not shield him from criminal culpability, since under the doctrine of common intention, criminal liability does not depend on who physically commits the actus reus, but whether the accused acted in concert with others to execute an unlawful purpose. Applying the legal principles governing the application of circumstantial evidence to the present case, and having in mind the law regarding the definition of principal offenders as stipulated in section 20 of the Penal Code, I am satisfied that the circumstances presented in this case, taken cumulatively, form a chain so complete that there is no escape from the conclusion that the accused persons, jointly with others not before the court, committed the offense charged. The evidence on record irresistibly points to the fact that the accused persons with malice aforethought unlawfully caused the death of Sharon at the material time. It is therefore my finding that the prosecution has proved its case against the first, the second, and the third accused persons beyond any reasonable doubt. I consequently find each accused person guilty of the offense of murder, contrary to section 203 of the Penal Code, as charged in count 1. Each accused is accordingly convicted under section 322 of the Criminal Procedure Code.
We are most obliged.
Most obliged. Most obliged.
We are going to request that you guide us into the next phase of this trial.
So, councils representing the state. I do not know, and I seek to find out from the council on record whether they are ready to take directions on the sentence hearing, and whether the councils representing the state are also ready with the information regarding whether or not the first accused person, the accused persons have any previous convictions or not, so that we are able to give directions on the way forward.
Yes, Melody. Apologies, I was late. I had a meeting that I had to attend. In regards to directions, we are ready to take directions on sentencing hearing. We would also like to be given time to get the reports on any previous sentences, so we can supply the same to the courts.
Just a minute.
We'd also be requesting the courts.
Okay. So, start again, Ms. Kikwe.
My lady, I said that as for the Republic, we are ready to take directions on this matter. We do not have the previous convictions report from the accused persons.
You are very fast.
Oh, sorry, I apologize for this.
You're saying you started by saying that you apologized for coming late.
Oh, yes, my lady, I apologize for coming late. I had a meeting which I'd been directed to attend. But I had a team of 3 prosecutors who are here. In terms of directions, my lady, we are ready to take directions on sentencing. We'd also like time to provide, to request and provide to the court reports on previous convictions for the accused persons.
You'd also like time?
Time, so that we can request from the DCI reports on any previous convictions of the accused persons. So we can supply the same to this court. My lady, we'd also be requesting the court to order for pre-sentence reports from the probation department. And for the same to be supplied before the next sentencing hearing date that will grant us. My lady, finally, in regards to the judgment you have given, we'll be requesting that the 3 accused persons' bail bonds be cancelled and for them to be remanded in custody. That is all, my lady.
Mr. Awar.
Thank you, my lady. I support the applications made by the state. Safe to add that and to emphasize that we request for a specific order for preparation and supply of victims' impact.
To emphasize that
we request for a specific order to the probation officers to prepare and supply us with victim impact statements prior to the date that will be set for sentencing.
that the probation officers prepare
and supply as well victim impact statements under the Victim Protection Act, Section 12. And the same be done prior to the date that the court will set for sentencing. Thank you, Melody.
Counsel for first accused.
Your Ladyship, I wish to address you on the request for cancellation of bail. That's the only issue I wish to address you on. Your Ladyship, the preparation of the reports from probation officers, including the victim impact report.
The preparation of the
Probation, yeah, pre-sentencing reports which the prosecution has requested, and the victim impact assessment reports. The preparation of those reports takes time. And so the date for sentencing is likely to take into account the period that will be taken in the preparation of those reports. Your Ladyship, the request by the prosecution to cancel the bail to which the accused persons were admitted to is not an unusual request. People are admitted to bail on account of presumption to innocence, which has now fallen off.
Okay.
However, Your Ladyship has judicial discretion.
Just a minute, Counsel, so that I do not lose you.
Yes.
You are saying that the preparation of these reports
will take time. Yes. In fact, most likely more than 30 days from experience will be taken in preparation of those reports. And I am saying the request made by the prosecution is reasonable, because people are admitted to bail on the premises that they are presumed innocent. That presumption has fallen
Slowly, Council.
Yes, sorry.
Yes, go ahead.
So, Your Ladyship, I was saying, with the guilty verdict that you've rendered today, that presumption falls off. However, the court still has discretion to extend the bail terms up to the date of sentencing. Your Honor, in respect of the first accused, he was released on bail on the 24th of October, 2018.
On 20?
On 2018, on 24th of October, 2018. That's when he was released on bail. And Your Ladyship, for the last 8 years, he has dutifully attended court whenever required. His passport, including his diplomatic passport, is deposited with the court. I ask Your Ladyship, in view of these circumstances, to consider extending the bail terms to the date of sentencing. That is all, Your Ladyship.
Okay, Council for second, please.
Thank you, my lady. Really, on behalf of the second accused, we are grateful for the judgment you have rendered. And we take cognizance of the submissions by my learned colleague, the prosecutor. Save us to my lady, since when the second accused was admitted on bail, he has religiously attended court. And even on the single instance when he didn't attend, he provided an explanation which the court didn't give a finding of doubt on the same.
Since the second accused was admitted to bond,
He has been religiously attending court, my lady. And on the single instance he didn't attend because of the reason for illness, evidence of the same was tendered before court, my lady. And to associate myself with the submissions of Malayan Senior Counsel Kilukumi, this court has discretion to extend bail until the date of sentencing, my lady. Which we hereby humbly ask the court to consider. That the accused be allowed to continue enjoying bail until when this court shall render sentencing. And again, we agree with my lady, senior my lady, that the sentencing report may take a while. We humbly pray, my lady, that's all.
counsel for that.
My lady, on behalf of the third accused, we also thank you for the judgment. My lady, to avoid rehashing what my colleagues for the first and second accused persons have said, first, we are ready to take directions as to the sentencing hearing. And in relation to the application for revocation of the bond and bail terms, on behalf of the third accused, my lady, we also pray very humbly that you be pleased to extend the bond terms of the third accused person. My lady, I will adopt mutatis mutandis the reasons afforded by my learned senior Kilukumi and my colleague Mr. Ogada. And just as a confirmation, my lady, the third accused person has also religiously attended for the last 8 years. And we'll pray, my lady, that you be pleased to exercise that discretion in his favor. Lastly, my lady, in the intervening period, my lady, we will pray that, and I believe I have seen my lady with a printed copy of the judgment. We will pray that if the same is ready, will be supplied with a copy of the judgment in the intervening period. Even as we wait for the sentencing hearing. That is all, my lady.